The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
We will prove to you that the defendant went into that room, raped as she slept, and continued to do so after she woke up and struggled to get him off of her.
Not a single time did they find a trace of Terence Crosbie's DNA.
I woke up to somebody on top of me, inside of me.
Did you rape?
We absolutely did not.
The fate of Irish firefighter Terence Crosbie now in the hands of the jury. So will the deliberations go as long as they did during the first trial? Plus, on the clock, a timeline and a deadline in missing Melodee Buzzard's case. We're taking a closer look into the beautiful 9-year-old child's family. Also this hour, could Courtney Clenny get bond? A hearing is set for the OnlyFans model scheduled in less than 2 weeks from now. Her defense attorneys join us live on the program this morning. And justice for Parker Schultes, her father, Christopher Schultes, accepting a plea deal in the hot car death. We're talking about it. It's all coming up next for you right here on Opening Statements. Good Thursday morning to you. Welcome to Opening Statements. I'm Julie Grant. We got a great show planned for you, so let's get started. Grab that cup of coffee or tea, or if you're across the pond, whatever you're having at lunchtime, it's time for my opening statement. Just when I thought Bryan Kohberger couldn't stoop any lower, he does. A hearing date of November 5th now set for the court to hear those arguments that we told you about the other morning here on Opening Statements over victim restitution. Killer Kohberger is fighting additional restitution payments to the family of Kaylee Gonsalves and Maddie Mogen. So the court's giving him an opportunity to be heard on the issue. What a scumbag. His lawyers argue in their motion that he won't be able to pay the amounts ordered because he's locked up and he's not working. He can get a job in prison. I don't care if he makes 2 cents an hour, he should be ordered to work every single day in that prison until he dies in it. And every single penny that he earns should go towards victim restitution. It is the principle here that matters. He wronged those families in the most cruel and heinous way, and because of him, they're now forced to suffer for the rest of their lives. And him working to repay them just some amount of money is still meaningful, because it's part of the justice for Kaylee, for Maddie, for Xana, and for Ethan. So if I'm that judge, I am ordering that lowlife to pay back every single cent to those sweet families. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
I told the dispatcher, I said, I think he sees me on the phone, I'm afraid.
Where did you stop?
Probably about 10 or 15 feet behind the car.
Did the vehicle leave again?
No, it stayed in the parking spot.
And did officers arrive at that time?
A lot of officers arrived at that time, and we were basically blocked in.
In New Hampshire, we've got the prosecution expected to rest today in the Amber Alert murder trial for defendant Dustin Duran. Court's getting it underway at 9 a.m. Eastern. We're going to go in together live when it begins. In Florida, we've got the murder trial over the death of rapper Julio Folio happening for defendant Alicia Andrews. She's one of 5 co-defendants. Court resumes at 9 a.m. She's accused in the ambush shooting. She's also the first defendant to go to trial. We'll see what happens. And in Massachusetts, we are on a verdict watch in the Irish firefighter rape case of Terence Crosbie. The jury deliberating for nearly 4 hours on Wednesday. The question is, will they go as long as they did in Crosbie's first trial? And that is our top story for you. So this guy on trial for a second time for allegedly raping a woman at a Boston hotel. The first jury spent 22 hours deliberating, ultimately leading to a mistrial. They were deadlocked. Now, before deliberations began on Wednesday, the jury got to hear the closing arguments. Let's look back at that.
Terence Crosbie
He is not the unluckiest man in the world. He's just someone who did a terrible, terrible thing to another person simply because he wanted to and because he thought that he could. But don't ignore the evidence. Why would you turn away from all of the evidence pointing to Terence Crosbie? Turn toward the evidence and find the defendant guilty for what he did.
Most importantly, he took the stand and told you in no uncertain terms he did not do it, and that they have not proven each and every element of the crime charged beyond a reasonable doubt. And for those reasons, I ask you to return the only just, appropriate verdict, not guilty. Thank you.
Now, defendant Terence Crosbie is charged with 1 count of rape. If he's convicted, he's looking at up to 20 years behind bars here in America. Now, remember, he's a citizen of the country of Ireland, just here for a parade, the St. Patrick's Day parade, which he never got to march in because he took off to the airport where he was arrested. He changed his flight to get home early. Why? Let's talk about this case. Let's get some predictions on the verdict. Be sure to share yours with us on social media as we welcome in our legal eagles. Joining us this morning, attorney John Phillips and attorney Kevin Brackett. Wonderful to have you gentlemen on the show today. So let's get some predictions on this. Are we going to see the same outcome, or is something going to happen differently with this different jury? John Phillips, would you start us off, please?
No, I didn't watch the first trial, so I don't know the actual differences. But in what I've seen of this trial and what I've read about it, you know, a lot of reasonable doubt exists. Certainly, there's a lot of circumstantial evidence, and leaving the scene of the crime, and you know, the way the DNA, while was inconclusive, you know, you have a guy masturbating, like there's a lot of things going on that a jury could hang their hat on. But I think we're, again, in for a long haul with possible holdouts based upon the amount of reasonable doubt that exists.
Kevin, let me go to you. You're a solicitor in South Carolina. That's the word you all use for prosecutor, for anybody wondering, and you've done it for a long time. So do me a favor, look at this from the lens of these prosecutors in the Commonwealth of Massachusetts. Assess the case for us. How strong, how weak? What do you think it is? What challenges do you see?
Good morning, Julie. Well, every case has, every sexual assault prosecution is a challenge unless there's, you know, conclusive evidence, and rarely is there a slam dunk. Oftentimes it just comes down to the word of the victim versus the word of the defendant. So here, you have that essentially, but on the side of the prosecution, you've got some other facts that I think are helpful. As John pointed out, I think the most damning fact is that he picked up and tried to leave the country 3 days before he intended to, or 3 days before his original plans. And then the excuse that he gave when the police pulled him off the plane, that the door was cracked, and I mean, that's just so weak and flimsy. It's obviously the best he could do on short notice. He thought he'd gotten away. I mean, the plane had left the terminal. But so you've got that going. On the other hand, you've got the problems of the inconclusive DNA and the fact that the victim was drunk. I mean, I think they're in for a long wait in Boston on this case. I think that the jury's got a lot to think about in there.
I see why this case has gone to trial. I get it. There are triable issues that you gentlemen just identified, both of you, you know, on each side there are issues. I can see why it went to trial. Let's take a look back together at a clip from the accuser, and then we're going to look at a clip from the defendant. Here we go.
I woke up to somebody on top of me, inside of me, in his penis in my vagina, on top of me. Telling me, you like this, he couldn't give this to you, I'll give it to you, he's a loser. I was focusing on getting out. I was focusing on getting to safety.
He was walking around the room, gathering her clothes and rummaging, looking for her belongings.
And did you look at her?
The lights were out. I couldn't, but I didn't try anyway.
Did you touch her?
I didn't.
Did you have any physical contact with her?
I didn't.
Did you rape?
I absolutely did not.
I absolutely did not, was his answer. Okay, so who came off more believable? Let's talk about that. John, let me go back to you. Your thoughts on these two key witnesses.
I think it depends on the juror, right? And it depends on what their background and experience is, because you have an emotional victim who is recounting one of the worst days of not just her life, but any woman's nightmare. She's just had a nice night out and, had some drinks, was kind of twice the legal limit in most states, but, winds up in this situation where she's raped or allegedly raped. And then you have him who's got a lot that doesn't make sense about the whole thing, but he was pretty emphatic. And so I think it's why we had a mistrial, is because different jurors will look at that based upon their own life experiences and wisdom and have a hard time coming up with a consensus. I do always tilt towards the victim, in these cases, but clearly we've gotten here through mistrials and juror lack of unanimous decisions. So I don't know that we've tipped the scales any further this trial.
Mm-hmm. And John, I really appreciate what you said about how jurors are going to look at things through their own lens of experience. It's something I think that you said so perfectly, because you go into the courtroom and you don't leave your common sense at the door. You bring into the courtroom that common sense and the way you view life. And so, yeah, I guess depending on who's chosen on that jury could really be the deciding factor here. Kevin, I want to go to you. Who did you find to be more credible in this case, and why, please?
Well, not just from how she said it, but the circumstances surrounding the case, and specifically the immediate outcry, and secondly, the fact that she's been through this once before and is putting herself through it again. She has no reason. There's no reason why she has, to do this to this man, but for this event. So why would she put herself through this twice if it didn't happen? So I lean into that. I do. He, of course, gave a direct and an emphatic sort of no, but it wasn't really emotional. And he looked down at one point. I always look for that. He couldn't keep eye contact right there at the end there. He looked down. And I always, I don't know, nobody can really tell whether someone's telling the truth, but that is sort of a tell for me.
That's a good tell, Kevin. Yes, I agree with you. I believe her. I've said it before, I'll say it again. I believe her. I don't believe him. And for some of the reasons you just shared, Kevin, the immediate outcry, when you say, after this event in question happened, she goes right to the hospital to get a rape kit. And I hope anybody watching this has never been in that position, but think about it. If you're traumatized in the most traumatic event in your life, and you can keep it together enough to go to the hospital and have a very invasive examination done, that says a lot. That is very hard to do. Nobody wants to go through that. She could have gotten in the shower, but I applaud her for having the wherewithal to go get the rape kit done. And I've said it before, just because the DNA test was inconclusive doesn't mean it's dispositive. It doesn't mean that he didn't do it. It just means that we don't have a definitive link from that science. And so I feel very sorry for this woman. I like you said, Kevin, she's not gaining money from this. John Phillips, you do civil work as well as criminal. If she was in civil court, there's a financial gain here. She's not gaining a dime from this. She's gaining more trauma is what she's gaining. So I believe her. Let us know on social media what you think. We'll leave it there for now. This case is going to start up with the verdict watch whenever the jury's in, roughly 9 o'clock. We'll put the clock up at that time. Right now, let's talk about what's next on Opening Statements.
He said, "Did you know that your granddaughter was missing?" And I said, "Missing?" He goes, "When's the last time you talked to your daughter?" I said, "I don't know, 2 years."
The clock is ticking in the search for Melodee Buzzard, a deadline now imposed for her mom to cough up some answers. Will we see an arrest soon? And OnlyFans model Courtney Clenny's trial happening who knows when. It's delayed yet again. And guess what? She's also got a bond hearing this week. She's been in for a while, so could she be released? Her attorneys join us live.
The Court TV podcast will return.
He said, "Did you know that your granddaughter was missing?" And I said, "Missing?" He goes, "When's the last time you talked to your daughter?" I said, "I don't know, 2 years, a year and a half ago." The psychologist that I was seeing said, I said, "Should I be keeping these things? I keep buying them for her for Christmas and her birthday." She said, "If you keep them for her, she'll know that when she was gone, you were thinking about her." So that's why I keep them. And sometimes I wonder, am I going nuts, right?
Oh my goodness, family members, including Melodee Buzzard's grandma, who you just saw there, remain hopeful this morning for her return. The missing 9-year-old continues to be have whereabouts unknown as investigators continue working the case. We've got a timeline here. I want to show it to you. Santa Barbara Sheriff's Office releasing this, detailing key moments in Melodee's disappearance. So here we go, going back to August 2025. The school district did verify a sighting of her. Then fast forward to October 7th, another verified sighting of Melodee and of Ashley, Melodee's mom. This begins a road trip to Nebraska. Ashley returns from the road trip without Melodee. Okay, so then a week later, October 14th, a welfare check's requested by the school district. Police say Ashley was contacted, could not provide any reasonable explanation of Melodee's whereabouts. Imagine that. Then on October 15th, detectives search the residence. Melodee not found, Ashley uncooperative. On the 18th, the FBI joins in the investigation. The FBI has been sending out this beautiful child's poster online. I've seen it lots of places asking for people to share, call in tips. On October 22nd, Melodee is remaining an at-risk, they call it an at-risk missing person, as her mother, Ashley, remains uncooperative. And as evidence continues pointing toward mom, potentially is acting suspiciously, at the very least. She has still not been charged and has not given an explanation as to where her daughter went. So with the clock ticking, we're wondering what's going to happen first. Is this beautiful girl going to be brought back home first? We hope for that. Or is mom going to be arrested first? Wouldn't be upset at that either. Let's bring in South Carolina solicitor Kevin Brackett and private investigator Manuel Gomez with Black Ops Private Investigators. Good morning to you both. Manuel, what do you think?
Well, I think she should be brought in at a minimum as endangering child welfare. Okay, this will cause them to now be able to have the tool to find out where she is. Okay, and I want to add another thing to this, Julie. This case has moved me so much that, I want to help this family. I want to help her. I also want to help Celeste Rivas. So I'm making an announcement now. I am going to offer $10,000 reward to anyone that can prove that this little girl's alive and information regarding Celeste Rivas with that guy, David. Okay. $10,000 to anyone that can show me her location or that she's alive. And at Black Ops Private Investigators, we will pay immediately. Please, if you see her, call us, and we will also contact the police.
Manuel, you're awesome. Boy, oh boy, thank you for that. Thank you for that, really and truly. You have such a big heart, and you're so good at what you do. I pray this child can be found alive. Kevin Brackett, what do you think? Will we see Melodee be brought home first or mom in handcuffs first?
I'm afraid we're going to see mom in handcuffs first, Julie. I'm very worried about Melodee. I don't think this is looking good from what I can see. When the police show up at your door and ask where your child is and you can't produce the child, and that's all you need to do, show them a healthy child to make the police go away, everybody would do that if they could. The fact that she's not makes me think that she can't. And that trip to Nebraska, that's half the country to look through. to try to find her. So I am not feeling good about Melodee's situation, and I pray she's okay. But I'm very worried about her. But I don't see us getting Melodee home before we see Ashley in jail.
I'm with you, Kevin. I think mom's going to be arrested first. We might hear of this happening tomorrow because we know mom was given 72 hours notice from Monday to either produce her child, her daughter Melodee, or be taken to jail. And so TikTok for mom here. Manuel, this is a tough conversation to have, but it's an important one, and it's the reality here. What do you think the odds are that Melodee could still be alive?
I don't think the odds are good because, like my colleague just said, if the child was alive, any parent would just stop all this harassment, the community pressure, people leaving signs on her door. She would have already told. And that's why we have to bring her in on endangering child welfare at a minimum, okay? Because this will force that mother to say where that child is. Unfortunately, I think this is another victim, as we've seen countless times, Julie, on Court TV, of children who've gone abused, killed, maltreated, doing homeschooling. We have to have those regulations in place. And this case has touched me so much. This is why I offered that $10,000 reward to find her. We have to stop this. And I'm tired of seeing children like this not being helped. And thank God that they're going to do it within 72 hours.
Exactly. Give her a time limit to do it. I love that, Manuel. So let's talk about something else. So the walls are closing in on Melodee's mother. Good. And the Southern California community where they live continues pushing for some answers.
We want answers! We want answers!
Look at this. So supporters of Melodee stood outside of Ashley Buzzard's home. They were chanting, demanding an explanation for Melodee's disappearance. They brought signs. Her mother, we know, is not making any statements publicly. Ashley's grandmother, however, is a different story. She spoke with KSBY during the search and had this to say about a call with police prior to her granddaughter going missing.
About 15 minutes later, a sheriff calls me. He says, I'm at your daughter's house in Orchid, and I was just getting ready to take your granddaughter Melodee with me to CPS because we're getting ready to take your daughter to the hospital. The house was in disarray. There were raw eggs in pans. There was rotten food in the fridge that I think she was trying to give my granddaughter.
Oh, my gosh. So what's going on with that family? Boy, oh, boy, that's just, it's infuriating. Manuel, your thoughts?
Well, you have to understand, the grandmother and also one of the other family members admitted that she has mental health problems. And she has a history of that. And not only that, but on another interview that I found with one of the family members, do you know that her other daughter was taken by the father because of child neglect? So there's a history here, okay? And the fact that you have that community screaming and chanting in front of that house and she's not showing where that kid is, Julie, it's not looking good. I don't think she's alive.
Yeah, this is so sad. We all pray that she's alive and well, but the reality is mom was the last person with her, drove her to Nebraska, returned without her, and isn't talking. It just, it doesn't make sense if she's alive. Kevin, what do you think about this family, this poor, helpless, beautiful child? Seem to be doomed here with this situation.
Yeah, one of the subtexts of this entire discussion, Julie, is the state of mental health in this country. The fact that she could be mentally unstable but still allowed to keep this child for that long. And there's a lot of great homeschoolers out there, a lot of parents who take good care of their kids. But one of the things you miss is the social safety net of school, having a child show up every single day so that if there is a problem, a teacher can spot it and call the authorities so that the child can be protected from parents like this. So it's really just a tragic situation, Julie, and highlights a number of issues that really need to be addressed, not just in California, but I think across the country.
Yes, Kevin, you're exactly right. You and Manuel both are raising that point. If there's no oversight, from our government, and people are just allowed to homeschool. We can't trust. Isn't that sad? We can't trust that it's being done right and for the right reasons. There are, I know some people who've done a beautiful job homeschooling their kids, personal choice, but they took it seriously, and the kids were raised so well and have grown up to be really successful. But when it's for other, more sinister, selfish reasons, incompetency, we've got to prevent that. Thank you both so much. Kevin, you're sticking around with us. Manuel Gomez, you got cases to work. Thank you for your expertise and for your generosity. You got such a big heart. We'll see you soon. And friends at home, thank you for staying with us. Go get some more coffee if you like. I'm going to do that. We're going to be back in just a couple minutes. Here's what's next.
Actually, done. Okay, fine. Done. Because you're costing me money. I didn't do because I got into this house because of you. You let Milan say some line that. No, because you flirting with 3 girls the whole time. 3 girls.
We're spotlighting defendant Courtney Clenny. Her trial delayed again. She's also got an upcoming bond hearing. Her attorneys are joining us live next to talk about it all. Plus, a plea deal accepted in the hot car death case against Father Christopher Schultes. Is it justice for his beautiful daughter, Parker?
Now, back to the Court TV podcast.
I have not always been a victim, but right now I'm a freaking victim in the situation.
He and the defendant, Clenny, had been involved in an extremely tempestuous and combative relationship.
Don't touch me!
What is going on?
He had my neck, and this happened twice before, where I couldn't breathe.
I was sober for 2 weeks. 2 weeks. And now why am I not sober? Because of you.
In our spotlight this morning, the case against former OnlyFans model Courtney Clenny is delayed yet again. And we're talking to her attorneys about it all this morning. So Clenny is accused of murdering her boyfriend, Autumn Sewell, during an argument that the couple had inside of their Miami condo back in 2022. Clenny claims that she threw a knife at Autumn Sewell in self-defense. She was arrested more than 3 years ago and has been held without any bond ever since. Here's her attorney, Frank Prieto, in court last week talking about the delays.
We need to get this moving. Again, Ms. Clenny's been in custody now 3 years and 2 months. It's time to get this in a realistic trial date position.
Prosecutors rejected claims that the state is drawing out the case, telling the court that the defense filed the motions to suppress evidence and reconsider her bond and dismiss the case, and that they had to deal with those. Now, the hearing to reconsider bond is now set for November the 4th, and the December 1st trial date has been postponed. The judge set a December 5th deadline to respond to the attorney's filings. No trial date is on the calendar at this point. So let's bring in Courtney Clenny's attorneys, Frank Prieto and Sabrina Puglisi. Good morning to you both. Thanks for coming back on the show. All right, so let's talk about where things stand now. Let's talk about the trial first, and then we're going to get to the bond. So many of our viewers, I'm sure you both can believe it, ask often, when's this case happening? When's it going? And I know I've asked you both often when you've been on the show, and unfortunately, we just haven't had a date. Sabrina, realistically, when do you think this is going to go?
Realistically, we're hoping for the first part of next year. Due to scheduling and all the motions, all the delays, Julie, that we've had. And much of it has been because of the prosecutorial misconduct with the breach of privilege. But we finally are past that. We're now getting ready to really go to the meat of the case, which is getting ready to litigate the motions. And then as soon as those are done, we'll be ready for trial. So yeah, realistically, I think we're going to be looking at the first part of next year, sometime in first quarter.
Okay, so wintertime, somewhere in there. I know you both have been preparing for a long time. We've talked a lot about the case. Frank, I want to turn to you about the bond. We saw you in court making those arguments. We know now the bond hearing coming up sooner than any trial, November 4th. We have a clip from what the prosecuting attorney, Sean Abuhoff, had to say, I might be mispronouncing that name, had to say about your client possibly getting bond. Let's take a listen.
Are you going to respond in writing to the reconsideration of the bond?
So, Judge, that's the hard part about this, is that there's not much that's new within this. There are, they're asking for reconsideration based off of the amount of time and the litigation that took place really over the last 18 months. It doesn't change the risk of flight, the dangerousness. It doesn't, I honestly don't believe that there's any form of evidentiary hearing that will be necessary. And it's one of those that certainly if Your Honor believes I should respond, I'm happy to. But I don't believe there are grounds in this to warrant the defendant's release.
All right, Counselor Prieto, what's your response to that, please?
Julie, thanks for having us again. But so listen, the prosecutor, he raises a fair point. He's indicating that saying that, hey, look, Judge, there's nothing new here. There's no new evidence. And so that the court should deny it. And Judge Goldson is going to consider his argument. She indicated she's not sitting in an appellate capacity to overturn Judge Cruz's decision. But we did raise new issues. And one of the issues, it's connected to our motion to dismiss. We found out in a collateral proceeding that a witness, the first person to enter Miss Clenny's apartment, was videotaping on his phone and taking pictures. And after the police were interviewing him, they instructed him to delete all his videos and all the photos, which was the pristine alleged crime scene. So this is new evidence that I think the court needs to consider. That this would have been helpful for the defense. It raises issues of the preservation of the crime scene. And I think that it's something the judge should consider along with the previous misconduct on the part of the government to say, hey, look, there is new evidence here. I can reconsider bond. And hopefully Courtney will be out while we prepare for her trial.
Whoa. Okay, Frank, we want to back the truck up with you. Back the truck. I am horrified. So, I guess first question, was whatever was deleted recoverable?
According to that civilian witness, he deleted everything at the direction of the police, and then that was approximately, and then he changed his phone. Look, the government should have been aware of this because the video that they turned over, surveillance video the government turned over to us from the elevator, shows this individual on his phone clearly filming. The government should have, they were in a better position when they had this before they even filed the case. They should have preserved that. They should have interviewed this gentleman. They should have served, iCloud warrants, whatnot on his phone. And it turns out he was never even interviewed by the state attorneys in this case. In fact, the lead detective never interviewed this guy. It was apparently a patrol officer who stood over him, according to his testimony, and made him delete all the video and audio. Now, what was on there, we don't know. Obviously, the camera wasn't there when the event took place, when Miss Clenny was defending herself. But this is what we call a Youngblood violation, destruction of evidence, and that's the basis for the motion to dismiss, which ties into our reason to ask for another bond.
Wow. I mean, I can't say I'm surprised. I mean, these things unfortunately happen. Good on both of you discovering that and being able to raise it as a viable issue for your client. And I would think, and I'm certainly not trying to speak for anybody or put words in anyone's mouth, but I would think the Autumn Sewell family would probably be disgusted as well, because if there was something, like you said, Frank, you don't know what's on there that they may want to see. Obviously they're very upset and coming from a different perspective than you both are. You're advocates for Courtney. I can't believe a police officer would tell a witness, to get rid of potential evidence. Can you share with me, was this a neighbor? Can you give us a little bit of an idea of who this gentleman was, if you know?
Yeah, Julie. Yeah, and listen, it is shocking. It's completely shocking to hear that whether it's a patrol officer or a detective, that they're destroying evidence, right? It's crazy, but this case has taken a turn for somewhat. There are so many issues that have come up in this case. You're well aware of the misconduct, the reading of our attorney-client privileged communications. It's absolutely crazy. It's bizarre, and it's a sad statement of how the justice system can work sometimes. But this gentleman was one of the employees of the condominium.
Oh, wow.
So he was there first with the security guard filming, which would have, revealed what was occurring at that point. It was minutes before the cops got there, the police officers. So.
Yeah, exactly. He was there before them. Boy, that's really unfortunate. But that's a really interesting issue, even if it doesn't support your position at the bond hearing, perhaps at trial. It's obviously you two are such pros. You'll explore that on your crosses. Sabrina, let me go back to you, please. We know that you all have filed motions to exclude many of the phone recordings. Courtney and Christian recorded each other, a lot of toxicity, as we know. The phone calls that he recorded that are very damaging to her, where does that stand?
We have that pending. What we had to do was to supplement just the exact recordings, and we've done that. We refiled that, and so that will be pending. I mean, the case law is really clear that surreptitious recordings should not be admitted into evidence. And honestly, when you think about it, this is the whole thing of what Christian used to do, right? He used to taunt her. He used to gaslight her, get her to a point, and then he would record her. We don't know anything of what occurred before those recordings started. And that's why not only is it illegal to record somebody without their permission, it also is very unfair because it doesn't portray exactly what occurred during the situations.
Yeah, tough case this is. I've said it before, I'll say it again. The best thing going for Courtney Clenny are the two of you, Sabrina Puglisi, Frank Prieto, excellent advocates you both are. And with this new information, we're going to have to reach out to the Autumn Sewell family. Perhaps Attorney Mike Haggard, maybe he'll speak with us and see if they would. I would be upset if I were them, and this is potential evidence that's been destroyed for no good reason. Thank you both for the new information. We'll see you soon, I hope. Coming up next here on Opening Statements, here's what we've got. Christopher Schultes pleading guilty in the hot car death of his daughter, Parker. We're breaking down the deal when we come back. And next hour, new developments in the case against former Sheriff Mickey Steins. His daughter is speaking out.
Do you all not have anything better to do than to sit and gossip? You are taking my pain and making it your pleasure.
This is the Court TV podcast.
Based off of our investigation at this point, right, we have determined that there's probable cause to go ahead and charge you for what happened. Okay.
Let's come out here, Christopher.
No.
It's okay.
No. Okay.
Yeah.
So, listen. No.
Christopher Schultes, the father charged in the hot car death of his 2-year-old daughter, has accepted a plea deal ahead of his upcoming trial. Schultes will now be pleading guilty to second-degree murder. As part of the plea agreement, sentencing will be set for November 21st, where Schultes will face consecutive sentences, which means he'll be behind bars for 20 to 30 years. Here's a look at the terms of the deal. Sentences running consecutively, 20 to 30 years of flat time with no eligibility for early release. He rejected the initial plea offer of 10 to 24 years in prison. Here's what Schultes would have faced if he went to trial. First-degree murder charge, life in prison, or the death penalty, potentially, or the penalties. Trial was set to begin next week. All right, so is this agreement justice for his daughter, Parker? Let's talk about it. Let's bring back in our legal eagles, Kevin Brackett and John Phillips. John, what do you say?
These cases are very personal to me. I sat in the deposition of a mother who lost her child in a hot car death that was in the car for 4 hours just yesterday. And the law needs to catch up and learn how to prosecute these cases better. Certainly 20 years, 20 to 30 years, is justice. But you've also got to realize that this child is now, passed away, and the siblings are going to lose this father. And there are no winners here through justice.
No, certainly not. Kevin Brackett, you know how tough these cases are as well. When you have a child involved and then the parents, the defendant, they've already suffered an immeasurable loss with the death of their child, but they still are deserving of punishment under the law. Your thoughts?
Well, Julie, we live in South Carolina here, and it gets awfully hot in the summertime. We've had a few of these cases in South Carolina over the years, and they kind of fall into two categories. The father who doesn't usually take his kid to work, but then one day or doesn't usually take his kid to daycare. One day he's got to do it, but he forgets. And the child falls asleep in the car seat. He goes to work, doesn't even remember the child's quiet, goes in, and then the tragedy unfolds. That's more sympathetic. It's still the responsibility of the guy. He's still screwed up. He still needs to be held accountable. Then you got the father who's inside the house doing meth for 8 hours, and he left his kid in the car. No sympathy for that. That's just murder. So the penalty needs to really match exactly what the father or the parent who neglected their child did. In this case, it seems like he's done it before. The text from his wife saying, I've told you not to do this. He's inside playing video games. He just doesn't want to be bothered, it sounded like. So I'm less sympathetic to this man. He seems to fall into the latter category, or closer to the latter category than the former.
Right, Kevin. We've got a statement from the Pima County District Attorney's Office saying, quote, under the terms of the plea, the sentences imposed by the judge are going to run consecutively, and Schultes will face a sentencing range of 20 to 30 years of flat time, meaning he's not eligible for early release. He must serve the full sentence imposed by the court and the Department of Corrections for murdering Parker Schultes on July 9th, 2024. John Phillips, this parent had complaints before. They were deemed unfounded, but nonetheless, unfounded by the state. His child, though, was put into the care of her mom. Could this have been prevented?
100%. The history of abuse. Anytime a parent, even by perception, is using a hot car or a car seat to babysit, that is an unfit parent. That is an abusive parent. And that's what we seem to have here. And it's intolerable. And I hope they throw the maximum at him.
Yeah, you're so right, John. Intolerable. That's a great way to put it. It's been such a treat having you both on the show today. John Phillips, Kevin Brackett, thank you both for your legal insights. We'll see you soon. And friends at home, thank you for being with us here on Opening Statement. That's all for this episode of Opening Statements, my friends. I'm your host, Julie Grant, and it's been great being with you. On this show, I am calling out any pants on fire moments in our big trials and true crime stories, and I want you to come along with me. Opening Statements is live every weekday morning at 8 a.m. Eastern on Court TV. Thank you for downloading this episode. Please subscribe, leave a review, and share it with your friends. You can watch past shows anytime you like on CourtTV.com.